SJC-13637, Michael Cannata versus Town of Mashpee.
Okay, Attorney Carter, whenever you're ready.
Good morning. May it please the court. This is an appeal from the granting of a motion to dismiss of the appellant's verified complaint seeking a declaratory judgment. The lower court basically interpreted Section 9 of General Laws, Chapter 32B, as requiring an employee to be a participant in the town's group health insurance at the time of retirement. Town argued that at the time of the deferment, Mr. Cannata should have applied and paid full policy rates until retirement. The facts of this case are that Michael Cannata was a firefighter in the town of Mashpee from September 8th, 1994 through December 19th, 2004, which was a service time of 10.25 years. The Barnstable County Retirement Board accepted Mr. Cannata's years of service as vested, and in fact, when he reached 55 on June 6, 2021, he started to receive his retirement from the Barnstable County Retirement Board. Simultaneously to applying to get his allowance from the Retirement Board, he requested the town of Mashpee to be able to re-enroll. He had been, during his 10.25 years, a full participant in the health insurance plan. When he turned 55, he asked the town to re-enroll, which the town refused. They first gave a reason being that he was not full-time, that he did not have full years of service. When Mr. Cannata showed evidence to the contrary, the town changed their position and basically said, well, we don't have a policy, but it's been our practice to not allow deferred retirees or retirees to re-enroll. Now, the courts have addressed this issue of 32B through a line of cases. The most relevant to this case, I would suggest, is the McDonald case versus the town manager of Southbridge.
Is McDonald I can't remember, there are 3 paragraphs. Is that a paragraph 1 or is it a paragraph 3 retirement?
For McDonald?
McDonald, I'm trying to understand what type of retiree McDonald was. Because I understand the appeals court decision, but I thought that the retiree was looked at as whatever when you fill your requirements. There are 2 different types of retirees, right? I may not be using the proper terminology.
Tenured retiree?
Sorry, I can dig it up, but.
So McDonald was a firefighter who...
I know the facts, but from what I understand...
He had an accidental disability retirement.
Right, but there's 2, again, I don't have the proper terminology in place, but the question is McDonald different from the SJC case because it deals with a different type of retiree as opposed to a deferred retiree, whatever the proper terminology
Sure.
is.
I would say no, because the issue that the appeals court hit, and this court has not overturned, is whether a person who retires, whether or not they can re-enroll after retirement into the town plan. And basically, the McDonald court said that there is nothing in the plain language of 32B, Section 9, that prevents a individual from re-enrolling.
Okay, but here's the terminology. Accordingly, Cannata is not a retiree by superannuation as contemplated under paragraph 1, but a deferred retiree who is required to follow the mandatory procedures in paragraph 3. That's what I'm trying to understand. What is McDonald, the employee in McDonald? Is he a deferred retiree like your client here, or is he a superannuated retiree, which is different?
He was not a deferred retiree.
So isn't that important?
No, because again, the appeals court addressed the issue of being the statute not precluding someone who wasn't on the plan from re-enrolling. The statute basically doesn't say you cannot re-enroll. So in other words, the paragraph 3 that the town focuses on, and that the lower court judge did, basically sets a precedent. But as the McDonald court in a note, basically addressed that. And paragraph 3 basically talks about an insured employee. Now, in this case, Cannata was not an insured employee. And basically, what the McDonald court said was, look, if you terminate your services prior to retirement, you have a right to stay on the plan. That's what paragraph 3 says. To stay on the plan, you have to fill out an application and pay 100%. What the McDonald court was talking about was other than insured employees, which is what Cannata was. He wasn't an insured employee. He was up until he deferred his retirement, and then he went to re-enroll. And again, the McDonald court based their decision on basically 3 factors. They looked at the broad policy of the statute to provide coverage. They talked about statutory language which admits of more than one reading, and they also relied on the Group Insurance Commission interpretation of a parallel.
I'm going to give you a chance to, your sister's going to stand up and argue the following from her brief. McDonald only applies to paragraph 1, superannuation retirement, and not paragraph 3, deferred retirement, which requires the employee to be insured for the continuation of benefits upon retirement. Tell me why that's wrong, okay?
Okay, so paragraph 3, reading from the McDonald decision, in their footnote, it says, it's noteworthy that the 3rd paragraph of 32B, section 9, which gives rights to employees who terminate their services prior to retirement, speaks of insured employees. The portion of section 9 we are concerned with does not say insured employees who retire, which is what Cannata was. He was not an insured employee at the time of retirement, and the McDonald court said there's nothing in the plain language of section 9 that prevents or precludes someone from re-enrolling.
Counsel, here's a question for you. Do you, in this, I don't know how to pronounce it, but the CIOC case, is that the CIOC?
I would have butchered it. No matter what.
Well, we'll call, with all apologies to the CIOCs out there, if that's wrong, I'm going to call it the CIOC case. In that case, the court was careful to note in a footnote that it was not dealing with the situation of deferred retirees. And my question is, the bottom line of McDonald and CIOC is that the statute doesn't preclude covering these people. And the question, it seems to me, is about, there are 2 parts. First, could a town have a policy of saying, we're going to cover the McDonald's of the world. We're going to cover the people who, at the time of their retirement, they've been in service, they haven't been using the benefits because they've got it from their spouse. At the time of their retirement, they say, I want to sign up for health care now, health insurance now. We're going to cover those people, but we're not going to cover the people who appear 12 years later as deferred retirees and then suddenly want to get retirement. Aren't they different? Those people differently situated, and the town, they're different kinds of retirees. And a town, theoretically, I'm not talking about this case, but theoretically could have different policies, clear written policies saying we will cover the McDonald's, we will not cover the deferred retirees. Is that true?
I would agree with you because I think that's what the CIOC
All right. So
case said.
given that we're in agreement on that, I think the real question here is about whether there's a policy, right?
And there wasn't. In fact, the town manager wrote and said, we don't have a policy.
But we have
We have a
Right.
practice.
And we are at the motion to dismiss stage, right?
Correct.
And in your client's complaint, you don't allege that the town has a policy
I'm sorry.
You don't allege that the town has a policy of the type called for in SEAC and McDonald.
That is, I don't allege that they have any
Right.
practice.
And
They
under
didn't
12,
cite
under
any
the
practice.
motion for 12B6, we have to take the allegations in your complaint as true, right?
Correct.
Okay.
Did you attach that letter to your complaint? You attached it. Didn't you attach the letter to your complaint? It's incorporated into your complaint, the town manager's letter?
Yes, yes. So in the Chiak case, this court basically said the town is free to adopt a policy. But there is no policy. And in this court, reemphasized or supported the McDonald case, saying that there was nothing in the statute that precludes someone from re-enrolling.
Let me ask you a question then to follow up on that. If the statute doesn't preclude someone from re-enrolling, but doesn't mandate a town to provide re-enrollment for a deferred retirement employee, and you don't allege that the town had and your allegation is that the town didn't have a practice or a policy, where does that leave your client?
He should, under the McDonald decision, he should have a right to re-enroll.
Why? Under what theory? Under the statute? The statute doesn't, I thought you've agreed that the statute doesn't mandate a right to re-enroll.
But as the courts have said, it doesn't preclude the right to re-enroll.
Okay, it doesn't preclude, but it doesn't mandate. It just leaves it sort of up to the town. And in this case, the town hasn't adopted a policy saying that the employee, the former employee, will have an ability to re-enroll. So on what theory does your client's claim that he's entitled to re-enroll rest? There's no policy and there's no statute mandating it.
So I look at it this way. He retires under the law with vested rights, so he gets one benefit. There's a statute that talks about how towns have to cover health insurance through retirement. That's what the courts have interpreted 32B to say. And by now, the court's saying, okay, you get this benefit over here, but you don't get this benefit over here. You have the years of service, and there's a statute out there that the towns accepted, 32B, that talks about insurance through retirement. And the cases have defined that as saying it doesn't mean that you have to be enrolled at the time you start taking retirement.
Well, I think the cases have said that the town can cover people if they were not enrolled at the time of retirement. And following up on Justice Walhojan's question, I recognize we don't necessarily have to do this at the motion to dismiss stage, but let's just grant that the letter is correct, right? And so the town manager's letter saying, the second answer, saying that, we just haven't covered these people. We haven't covered these people, but we haven't put that in writing. So the implications of your argument, if your client is to prevail, is that every town that doesn't want to cover these people has to put in a policy saying, we don't want to cover any of the people we are potentially allowed to cover to the full extent of the law.
It's like the Galinsky case. In that case, the town of Irving put a policy in that this court basically said was in violation or contradicted the statute. So it's a local option statute. So if a town decides to accept 32B, then they are accepting it. But they have the right to limit it as long as it's in...
Well, hold on. You just agreed that the statute doesn't positively provide itself, compel towns to cover deferred retirees who were not previously enrolled, correct?
No, because I think 32B, the way it's been interpreted, basically says that this is a plan. Once we cover an employee, it's a plan from active service through retirement. That's really what 32B says.
So you think that actually he does have a right under the statute and that the town could not put in a policy saying we are not covering deferred retirees?
No, I think the town, based on the Chiak decision, can put in a policy specifically.
Well, then
In this particular case, they didn't.
Well, in that case, I don't understand the argument. If a statute mandates that a person in your client's shoes can receive insurance upon retirement, then how could a town have the authority to undo that with a policy if it's a statute, a state statute?
The town, based on a CHIOC decision, a town can adopt a policy limiting or addressing, as long as they don't violate the statute. Right. And in CHIOC, they basically put a thing in that said, hey, we won't insure you unless you were insured with us at the time of retirement.
That's why you need McDonald. McDonald's the only case that says if they don't put their policy in writing, you win. Right? That's your
correct.
whole argument is based on McDonald's, Justice Drebin's opinion in McDonald, which says because they didn't put it in writing, they can't rely on it. But again, it wasn't a deferred comp case. It was a case in which the employee had been receiving health insurance from their spouse, right?
Yes,
So again, but your whole argument is literally based on McDonald.
it is.
Yeah.
It is, and the fact that the statute is there to help people who dedicate or you put the years of service in that allows them to receive their retirement allowance. And so and the McDonald case says that statute carries over through retirement. There's nothing in the statute through Larson, through CHIOC, through Galinsky that says that you cannot preclude someone from re-enrolling. Those cases have all stood the test of time up until now. So I would suggest respectfully that Mr. Cannata should be allowed to re-enroll into the town.
Okay,
Thank you.
Thank you. Attorney Whalen.
Good morning, Chief Justice and Associate Justices. May it please the Court, Susan Whalen on behalf of the Town of Mashpee. The town is respectfully requesting that the Court affirm the lower court's motion to granting of the town's motion to dismiss under 12b-6. The lower court correctly applied the facts alleged in the complaint to the plain meaning of Section 9, Paragraph 3, and this court's precedent in Larson v. School Committee of Plymouth, in finding that the appellant failed to plead sufficient facts to establish that he was entitled to opt back into the town's health insurance plans upon his deferred retirement 16 and a half years after his voluntary resignation and his admitted non-participation in the town's health insurance plans during the entire period of his deferral.
Can you just walk me through how Section 9, Paragraph 3 requires a person who who's entitled to retirement but defers it, how that requires upon retirement for the former employee to have complied with Paragraph 3. That is, I'm sorry I asked such a confusing question. Paragraph 3 to me, at least literally read, seems to be about that interim period. The period when the employee leaves the public employee, the municipality's employment, is doing something else but hasn't retired, but is entitled to retire at some point, and then retires. So during that interim period, before retirement, Paragraph 3 governs. Upon retirement, it seems to me, Paragraph 1 starts applying to that person.
Well, Your Honor, you're correct that Paragraph 3 does refer to specifically for deferred retirees, and it is the statutory scheme that the legislature enacted and amended the law in 1971 to address specifically this group of employees who meet the minimum of credible service, 10 years, vest, go away for decades and decades in the private sector, where else, not in public employment. And then when they meet the statutory age, they can receive their retirement benefits, which is separate, obviously, and not paid for through the town's municipal finances. It comes out of the retirement system. And then, unbeknownst to the town, come back and say, town, taxpayers, we want you to now to pay for mine and my dependents' health insurance for the rest of our lives. That is completely contrary to the legislative intent of Chapter 32B.
I'm just sticking to the words of the statute. So paragraph 3 starts with prior to retirement, and then discusses the steps that somebody who has the years of service but is too young to retire needs to do. And then, so it seems to me paragraph 3 covers that interim period prior to retirement.
That's correct.
Whereas paragraph 1 is about upon retirement.
That's correct.
And so Mr. Cannata is now paragraph 1 employee because he's retired.
But that, if to make that, to have that interpretation, Your Honor, that completely negates the provision of paragraph 3,
Well,
which is
paragraph 3 would still have some meaning for that interim period.
But that the court's precedent, which is completely on paragraph 1, which is about retirees, and as Justice Kafka had asked my brother previously, paragraph 1 is different than paragraph 3, and that was distinguished in McDonald. All that is a retiree continues. The law requires the maintenance and the continuance of health insurance benefits for a retiree in paragraph 1. The town, by any policy or procedure or practice, could not negate that requirement, and the town does not. If you have pre-retirement enrollment, that is maintained, pre-separation. The appellant did participate in health insurance. He separated in 2004. He then left for 16 and a half years and did not continue it. So there's nothing to be maintained. There's nothing to continue into his retirement into 2021.
Well, if you read it as paragraph 3 being a requirement for paragraph 1, which is, I think, what your position is.
The position is that
in order for paragraph 1 to trigger, the employee who retires, who leaves the employment early, needs to continue that insurance, health insurance, through that interim period with the town.
That's correct.
In order for them to get paragraph 1 insurance upon retirement.
Right,
And I'm wondering where in the statutory language you're seeing that.
Well, this court, in the statutory language, it was clearly amended in 1971 to extend these benefits to deferred retirees. They could participate, but they had to apply, and they had to pay 100% of the premium. I would submit that that's...
And in 1971, when that happened, was there some explanation that these deferred retirees needed to have done that in order to, upon retirement, get the health insurance of paragraph 1?
The legislative history is silent on that, Your Honor. What it is, though, what one would believe that, or at least interpret what the legislative mandate is, since Chapter 32B is a comprehensive scheme, and it is a cost savings plan, which is what the legislature has been for decades and decades been concerned about, is how do we maintain health insurance costs for cities and towns and municipalities. And since there is the continuation and the maintenance of insurance for paragraph 1 superannuation retirees, they do get the greatest benefits. This court has held that previously.
Excuse me, counsel, just to go back to the text of the statute. So I assume that you think that the strongest argument that you have in the first paragraph of Section 9 is simply the words "shall be continued," which is to say that, upon retirement, your health insurance benefits shall be continued, and if you have not been having any benefits for a very long time, there's nothing to continue.
That's correct.
In response to that, though, how do you deal with the first sentence of the third paragraph, which doesn't actually the first clause leading up to the semicolon, which doesn't really concern requirements for how to continue during the interim period, but says prior to retirement, an insured employee who terminates his services, who has a right to retire but whose retirement is deferred, shall, for purposes of this chapter, only be deemed to have been granted a leave of absence without pay. So paragraph 3 instructs us that we're supposed to have considered Mr. Cannata as having been on a leave of absence without pay. And so he does have something to continue, right? Does he not? Because he was enrolled at the time of his leaving his position.
Yes, but he didn't do that. I mean, if he had continued and maintained and followed the statutory steps and had paid 100% of the premium for those 16 and a half years, he would then be entitled to have his participate in the town's plan upon retirement. I think what isn't clear and potentially could need to be further defined by this court is at what rate. Section 3, paragraph 3 clearly says deferred retirees are a lesser class than a superannuation retiree in paragraph 1, and they must pay 100% to maintain their coverage and their participation. When they do retire, and if they had done that, which the appellant clearly did not do, and it's undisputed, when they do that, at what rate do they participate in the town? Do they reap the benefits of 9E, which the town provides 75% of the premium? We would submit that the reason the legislature put in paragraph 3 and in fact made it onerous, which is make it difficult, if you have only 10 years of service, you go away for decades and decades and decades, and you don't pay that 100% and maintain your participation in the town's plans, then you could come right back after decades, and the town doesn't even know who these people are and what their potential reliability is.
Before going too far down the policy argument, as I understand your argument so far, you cannot point to any language in Section 9 that makes entitlement under the first paragraph subject to the third paragraph.
They're just separate classes of retirees, Your Honor.
Right, so entitlement to whatever paragraph 1 provides is not explicitly contingent upon having opted to pay for your own insurance during the period of leave of absence under paragraph 3.
Well, we believe that paragraph 3 is a condition to be able to.
If you say that, I'm going to ask you to show me the language that says it.
It's not in the specific language.
Okay, so I asked about whether it's explicit, so there's nothing explicit. Is this where then your argument about the town's practice comes in?
Yes,
Is that
Your
where
Honor.
you're trying to fill the gap in the statutory language?
And in the legislative intent, that towns, just because someone has had 10 years of vested service and is able to participate in, after decades, and receive benefits from the separate bank, which is the retirement system, they can't come back into the town and ask the local taxpayers to pay for theirs.
I understand the policy argument. I'm trying to get at a separate issue. Do you have any legal authority for the proposition that we can look at a town's practice in interpreting a state statute to fill the gap, a language gap, in the state statute?
No, Your Honor, no practice or policy that the town could enact would supersede specific and clear statute.
But here we're talking about a gap, because I think we just established that there's no explicit language making paragraph 1 entitlement subject to paragraph 3 participation.
That's correct, there is a gap, but again, under the policy of Chapter 32B and the legislative intent, they put that there for a reason, and they made it onerous.
All right, so let's assume we were to adopt this argument, your argument in that regard. And so the outcome in some way, depends upon the town's practice. How could the town's practice properly have been determined on a motion to dismiss? Wouldn't that have required factual development?
Well, there was attached to the
There were
plaintiff.
attached to the complaint were contradictory explanations from the town.
Well, there were the letters that explained there were two reasons. One, the plaintiff was not enrolled upon retirement, which has been the town's consistent practice.
But regardless of what the letters say, 12b-6, remind me of the standard. Don't we have to view things in the light most favorable to the
Absolutely,
claim?
Your Honor.
Okay.
Yes. And
So the most favorable for Mr. Cannata would be that there is no town policy. They're just making the stuff up.
well, again, the town does have a practice, and
But that's not in his complaint.
well, the town, he does state that the town failed to provide a practice
Right.
or policy,
Right.
a written policy. The issue is the town has a practice, and is this court would then need to say that, well, the town has to have it in writing and anticipate.
Or we need to know what the practice is, given the contradictory things that are in the letters, right?
Well, the letters, I don't believe are contradictory, Your Honor. I believe that they state that there were two reasons. One, there wasn't retirement enrollment, which is required. So everyone who in the town who is continued into retirement has had
So
enrollment.
can I ask you just to pivot back to the legislative intent? Because you said the legislative intent of paragraph 3 was something, and I'm trying to figure out where you found that.
Well, in terms of looking at the overall legislative intent of 32B, clearly 32B is a cost savings plan, and the sole mechanism which cities and towns may provide and purchase insurance benefits for their employees and their retirees. So we have all of the legislative history which this court has.
So you're saying because the intent was cost savings, paragraph 3 registration during this interim period is required because that would be the most cost savings for the town?
Absolutely, Your Honor. I mean, here you have, in the case at bar, we have someone with the bare minimum of vested time, which is 10 years, 10.2 years, but in this case, and went
Is there
away.
any argument that letting Mr. Cannata re-enroll as a retiree actually results in some cost savings?
Doesn't cost and cost saving. It results in tremendous cost and burden to the municipality.
Even though he's one more participating as a group?
Absolutely. I mean, as I'm sure you know in your own private experiences, that health insurance and the cost for health insurance is extraordinary, and that's one of the main drivers for cities and towns is the extreme cost that it has on their fiscal well-being.
Can I ask you? And you articulate a very sound public policy argument to your position. Do we have cases that say that the legislative intent and how we view the statute coincides with that public policy argument?
That is a cost savings?
Right.
Yes, Your Honor. I mean, this court certainly in Connors v. City of Boston, which is a 1999 case, I believe, went extensively through the legislative history, as well as this court most recently in Boss v. Town of Leverett in 2020, again addressed the legislative history, that it is clearly a cost savings mechanism and scheme that the legislature has been for decades and decades, right from the beginning, intended to have the most advantageous plan for cities and towns. You know, the economies of scale, the ability to provide benefits.
So with that lens, we then read paragraph 3 as a precondition to paragraph 1.
That is how the town has read it, and that is why we don't need a policy. Paragraph 3 is the law. There's no policy that the town can enact, written or otherwise, that can supersede the law. We believe that Section 3, Paragraph 3, is a condition precedent. It's a necessary bridge that brings a deferred retiree who has the minimum level of service, 10 years, decades later, and if they meet those conditions, then yes, they're welcome back into the town's plan. Because again, the town has an obligation under paragraph 1 to continue health insurance benefits.
Except that paragraph 1 says that the employee shall, under paragraph 1, shall pay the full premium cost.
Well, and then that was, of course, amended, Your Honor. That's the default provision, certainly as this court addressed in
Right, the
Galinsky.
town could have chosen to stick with paragraph 1, but instead the town chose under paragraph 9E
Correct.
to pick up more.
Yes, and that's just, it's just, as this court has held, that's just the amount of contribution by the town. It doesn't, 9E, adopting 9E, when the town did in 2004, doesn't supersede the continuation of benefits in the default provision, which is section 9, paragraph 1.
Sorry, just one clarifying question. So in your view, if he had done the bridge, as you said, and been paid full freight for all those years, would he then have to continue to pay full freight upon retirement, or would he then switch to being a paragraph 1 retiree upon retirement?
Your Honor, respectfully, I believe that is the question for this court. It's not clear. I think you can make an argument both ways. I won't pretend or stand in your shoes as to which way it should be.